What's the name there?
Agubosim.
AGU
BOSIM.
What are the initials?
BC, blessing C.
Okay. Very well. This is my ruling in this application. I have carefully considered the processes filed and the submissions of the parties. Counsel to the respondent urged this court to hold that this application cannot be granted in the absence of the judgment of the court sought to be enforced. No authority was cited by counsel to the respondent to that effect. Wait a minute. In Nathaniel Agumbiade and another versus Busayo Oluwole Uke and 9 others, one of the issues that arose in the tribunal was whether failure to file a list of witnesses in accordance with paragraph 4.5A of the first schedule to the Electoral Act 2010 is fatal to the petition, as paragraph 4 sub 6 of the said first schedule simply stated that in such a case, the secretary of the tribunal shall not accept the process for filing. The trial tribunal held that the non-filing of the list of witnesses to be fatal to the petition. But the Court of Appeal, per the leading judgment of Abiri JCA, set aside the decision of the trial tribunal on the ground that since the secretary had accepted the processes in question with the defect, the trial tribunal was bound to hear the petition on its merit. In like manner, since the registrar of this court accepted the processes as filed by the applicant, this court is bound to hear this application, and I so rule. It is the applicant's submission that judgment was delivered in suit number NICN EN 26/2014 between the applicant and respondent on 10th April 2019, that the said judgment delivered in this suit is a monetary judgment with 10% interest, amounting to the total of 5,297,203 naira 5 kobo, 10th February 2021, and any other month until the judgment debt is liquidated. Order 49, Rule 6 of NICN Rules 2017, under which the applicant approached the court, states under sub-rule 2A and B that this application shall be supported by an affidavit identifying the order or judgment to which the application relates. And if the judgment or order is for payment of money or stating the amount originally due thereunder and the amount due on the date of the application, stating that a demand to satisfy or comply with the judgment or order has been made on the person liable to satisfy it, and that the person has failed and refused to do so. It is pertinent to observe that, as pointed out by the respondent, the applicant did not avail the court with the judgment or the demand letter referred to. On whether the rules or practice must be complied with, The Court of Appeal in the case of Nigeria Electricity Regulatory Commission versus Adebiyi heard per George Will, JCA, thus. It is true that the rules of court are neither meant to be toyed with nor made for the fun of it. Thus, a party in breach of same is usually required to take steps to regularize his processes or his position within the context of the applicable rules of court. Rules of court are truly handmaids to the court for the attainment of justice. Thus, they are never to be allowed to become clogs in the wheel of doing expeditious and substantial justice to the parties. It follows, therefore, that whenever it appears to a court that a slavish adherence to a rule of court would result in either absurdity or injustice to the parties, the court is under a duty to rise above such a rule to ensure that the cause and or course of justice is better served without being slaves to such a rule. See Sholanke versus Shomefun. See also Unilag versus Igoro and UTC versus Pamote and Aishton versus Saraki. In the instant case, a copy of the judgment in the file was utilized in this ruling. Order 49, Rule 6, Sub Rule 3 of the court rules provides that the court, on hearing the application, may grant leave in accordance with the application or may order that any issue or question, the decision on which is necessary to determine the rights of the parties, be tried in any manner in which any question of fact or law arising in an action may be tried, and in either case may impose such terms as to cause or otherwise as it may think just. By this rule, the court may determine application on the basis of rights. In the judgment of this court in suit number NICN EN/26/2014 between the applicant and the respondent, delivered on 10th April 2019, this court made the following declarations and consequential orders in paragraphs 49(1), 2, 4, and 8. Order 49, section paragraph 49(1) says it is declared that the suspension of the claimant by the defendant is wrongful and unlawful, the same having been carried out by the defendant without recourse to the terms of the employment contract between the claimant and the defendant. 2, it is declared that the claimant's appointment as bank manager in the defendant bank remained subsisting for 18 months with effect from the date of suspension, that is 1st September 1999 to 1st May 2001. 4, the defendant, its servants, agents, or privates are ordered to regard the claimant's employment in the services of the defendant as subsisting until 1st May 2001. Number 8, which is the consequential order, is that all the sums payable under Order 4 above are to be computed and paid within 30 days of this judgment, failing which they shall attract interest at the rate of 10% per annum. 3 years and 3 months after the judgment of the court in this suit, dated April 10, 2019, the defendants have neglected, omitted, and or refused to comply with the orders made in this judgment, the judgment of this court in this suit. The defendant has not taken steps to compile records of appeal and/or transmit same to the Court of Appeal. The defendant has not taken any step to seek leave to appeal this judgment. The defendant is irredeemably in crass disobedience of the court's orders and liable to the consequences thereof and appropriate sanctions. The excuses of counsel to the defendant about COVID-19 and creation of Court of Appeal, Oka Judicial Division, are absolutely untenable. I stated earlier that by Order 49, Rule 6, Sub Rule 3 of the Court's rules, the court may determine this application on the basis of rights. That being the position of the rules of procedure in this matter, it is hereby ordered as follows. 1. The respondent is given 14 days from the date of this ruling within which to comply with Order 4 and the subsequential Order 8 of the judgment of this court by computing and paying applicants 18-month salary into an interest-yielding account of this court with the name the Chief Registrar, National Industrial Court of Nigeria, pending the hearing and determination of the appeal. 2, the respondent is given 21 days from the date of this ruling within which to compile and transmit its record of appeal to the Court of Appeal. 3, the orders made in this ruling shall be reviewed as it may become expedient so to do in the interest of justice. Ruling is entered accordingly.
As the court pleases.
As the court pleases, so grateful, my lord, for this erudite ruling.
Today is what date? 28. The second ruling in this matter is between Comrade Mrs. Iyedo Eki versus the Provost College of Education, Warri, and 2 others. Can I have appearances of counsel?
Please, my lord.
Yes.
I am J.A. Otodo.
Your initials are what?
J.A. J for justice. A for Azubike.
Yes.
J.A. Otodo. Otodo is spelled O-T-O-R-O-U-D-O. I most humbly hold the brief of M.A. Umako. M.A. Umako for the judgment creditor applicant.
Yes, who is appearing for the respondent?
With profound respect to Milord, sir. I'm S.O.
Yeah.
Oluku. S.O. Oluku. I appear with respect, sir, for the respondent.
This is my ruling. I have carefully considered all the processes filed and the submissions of the respective parties as far as the objection of the defendant. the defendants are concerned. The issues raised by the defendants are similar in content. I shall therefore consider this application on the common issues formulated and argued by the parties. Before I delve into the substance of this application, I must start with a preliminary point. It is the duty of counsel to always bear in mind that legal work is one that requires not only skill on the part of its practitioner, but it does require meticulous and due diligence. In this wise, therefore, learned counsel must ensure that as a minister in the temple of justice, where only learned men practice, the proof of true learning must be exhibited, not only in advocacy, but indeed in the drafting of legal documents. I cited Magaji versus Kuyambana. For instance, in paragraph 3.3 of the first defendant's respondent's written address, it is stated thus, I'm quoting, "It is not the only law relation to this application," close of quote, instead of related to this application. In paragraph 3.4, it is stated, I'm quoting, "is the Sheriffs and Civil Procedure Act," close of quote. Should be, it is not Procedure Act, it is Process Act. This is repeated in paragraphs 3.5, 3.6, and 3.8 of first defendant's written address. The appropriate rendition should be Sheriffs and Civil Process Act, not Procedure Act as rendered by the first defendant's counsel. In paragraph 3.6 of the written address, what is stated in line 3 thereof is, I'm quoting, "it must out necessity of the law," quote, "is unfathomable." Paragraph 3.19 of first defendant's written address, especially lines 1 and 2, states in part that this application for committer, prison of the first defendant respondent, is quasi-criminal, which require that the allegation of what constitute the content, closing of quote. The gist of what is there is in the ruling. The first defendant stated in paragraph 3.5 of his written address that the preamble to the Sheriffs and Civil Process Act, Cap 86, Laws of the Federation, reads, "An act to make provision or the appointment of sheriffs, the enforcement of judgment and orders, and the service and execution of civil processes of the courts throughout Nigeria." That since this application by the claimant, judgment creditor, applicant, way of enforcing the judgment and orders of this court In the words of, in the words of Naemeka Agu, JSC of blessed memory, in Ogbonna versus AG Imo State, the Supreme Court stated that it is necessary to note that a preamble to an enactment is, why is this thing like this? You're just sitting there, not watching. Not putting it though. You better sit so that you'll be watching the screen. Yes, as I was saying, I cited the case of Ogbonna versus Attorney General Imo State, in which Naemeka Agu JSC of blessed memory in Ogbonna versus AG Imo State stated that it is necessary to note that a preamble to an enactment is, as it were, its preface or introduction. The purpose of which is to portray the interest of the framers and the mischief they set a key to open the understanding of the enactment. I cited Inakoju versus Adeleke and Waifo versus Pende State and others, and Oyekwe versus Odemba. The citations are in the ruling. The preamble or marginal note serves as an indicator or signpost of what the section sets out to provide or achieve, and the mischief at which it was aimed by the lawmakers, even if it is occasionally misleading. First defendant argued in paragraph 3.21 of its written address that if an appeal exists with respect to the judgment, the subject matter of this application, then the application is inchoate, premature, and unsustainable because the law is certain that a person cannot be in contempt of an order that he is challenging. By way of appeal, he cited the case of Ume Akwana versus Ume Akwana. Notwithstanding, the citation is there in the ruling, notwithstanding the clear rendition of the judgment of this court in this suit, the first defendant went on regarding the functions of the provost, appointment of staff, establishment of council, functions of council, and composition of council. The applicant had stated in paragraph 4A, B, C, and D of her further and better affidavit in support of her application that the appeal allegedly filed by the defendants is not an appeal, but a proposed notice of appeal, that the defendants have not filed any appeal almost 2 years after this court delivered judgment in suit number NICM/LA/96/2012 that neither the defendants nor counsel has approached this court for compilation of records of appeal, that the purported appeal, Exhibit P1, is seeking for leave to appeal, and up till this instant, no leave has been granted by the Court of Appeal. In the same case of Umuakuna versus Umuakuna, the Supreme Court went on to hold per Peter Odili, JSC does. I'm quoting now. It is to be noted that the respondent did not comply with the order of the trial court to give the now appellant further and better particulars of the alleged non-compliance with the provisions of the said act or rules. The said order of the trial court was not set aside, and so it remains rock solid. Therefore, there is no basis on which the respondent can be heard to complain about non-compliance with the rules at the Court of Appeal when respondent herself was in disobedience of the order of the trial court. This court, and in fact, courts of our land, deprecate in very strong terms a party flouting of a subsisting court order, and while in that disregard of the order, seek a remedy at the higher court while remaining in contempt of the lower court. Cited AG Anambra State versus AG Federation and others. Also cited military governor of Lagos State versus Chief Emeka Ojukwu. The citations are in the ruling. In this case, the respondent, I'm continuing with the Supreme Court judgment. In this case, the respondent, being aware of what she termed non-compliance with the rules, did not complain from beginning to the end of the trial court, only to turn around when she got to the Court of Appeal to raise the matter. Indeed, the respondent slept on her right to complain, and even then was in contempt of the order of the trial court earlier made to furnish materials. Therefore, she lost the right to object on the issue, especially in the instance she has not established what miscarriage of justice has been occasioned to her in the light of the non-compliance. The reason of the claimant's applicant's motion on notice and the order of committal sought from the court against the defendants is the disobedience, neglect, or deliberate refusal of defendants to comply with the order of this court in suit number NICN LA 96 2012, dated 16th June 2020, that in response to correspondences, the first defendant replied, applicant solicitors, the claimant's letter is already receiving attention from the appropriate quarter, that defendants are acting in utter disregard of the judgment and orders of this court by this long and deliberate refusal of not complying, that despite the service of notice of consequences of disobedience to order of court on the defendants, they persisted in their refusal to comply with the judgment / orders of this court, that it is in the interest of justice and development of the law that first defendant be committed to prison for contempt of court. In reaction, it is the contention of the first defendant that the judgment and order of this court in this suit, the basis of this application was appealed to the Court of Appeal by the Ministry of Justice, that the first defendant has not deliberately disobeyed the order of this court, as he is not aware and does not have the details of the case and judgment in favor of the claimant, judgment creditor applicant, that he only became the provost of the College of Education, Warri, in the month of June 2021, and the governing council of the college has not instructed him on steps to take in relation to the applicant's case. The first defendant went on that he was not personally served with any Form 48 or 49 or 87 or 48, 49 or Form 87 or Form 49 and 87. That he is willing to comply with the judgment or order of this court once it is brought to his notice by the applicant and instructed by the governing council of the college that it is in the interest of justice to refuse this application. On how to commence contempt proceedings, the Court of Appeal stated in Onowu versus Ogboko and others, per Mbaba, JCA, thus, I'm quoting Mbaba now. This court, in the case of Mwaka versus Dikaku, heard 6, spelled out the ways of commencing contempt proceedings. Thus, there is not only one way of commencing contempt proceedings. A, where the contempt consists solely of disobedience of an order of court, the only acceptable procedure for commencing the proceedings is as provided in Section 72 of the Sheriffs and Civil Process Act and Order 9, Rule 13 of the Judgment Enforcement Rules, made pursuant to the Sheriffs and Civil Process Act, that is, by issuance of Forms 48 and 49, close of quote. To the first defendant, the claimant applicant woefully failed to comply with Section 72 of the Sheriffs and Civil Process Act and Order 9, Rule 13 of the Judgment Enforcement Rules, which stipulate that an application for committer must, as a matter of strict law, cause Form 48 and 49 to be issued by the Registrar of Court and served personally on the first defendant before the applicant can file a motion for an order of committer. By PDP and others versus Barrister Ezonwuka and another, the law as established by the Supreme Court per Kekere-Ekun JSC is that in order to do substantial justice between the parties, the court is entitled to look at its file or record and make use of the contents. Some citations supporting that are in the ruling. On the requirements of personal service of processes, In commuter proceedings, Court of Appeal held in Udoji and another versus Ukayobu and others, Awotoye, JCA, held us, quote, "It is important at this stage to stress that service of processes under Order 9, Rule 13 of the above rules must strictly be personal." CFCDA versus Koripamo Agari. The citation is there in the ruling. Substituted services is not acceptable under the said rule. What is to be served on the alleged contemnor under Order 9, Rule 13? It is a copy of the drawn-up order endorsed with a notice in Form 48, were the respondent physically present at the time the judgment was delivered, or were they represented? If they were merely represented, then strict interpretation of Order 9, Rule 13 of the Judgment Enforcement Rules, they were absent and needed to be served with Form 48 and a copy of the order. Once the drawn-up order of the court was not served, the entire commuter proceedings collapsed like a pack of cards, close of quote. Paragraph 20 of the case file indicates that Form 86, that is notice of consequence of disobedience of orders of court and judgment order in suit number NICN/LA 96, 2012, dated 16th June 2020, was received in the College of Education, Warri Provost Office on the 20th of October 2021. The stamp narrating the name, designation, signature, and date of the receiver of the original copies of Form 86 and the judgment order is blank. That means the name, designation, signature, and date of the receiver of the original copies of Form 86 and judgment is not shown on the stamp. However, at page 21 of the case file, Onukuli Chisom, the court's bailiff, deposed to an affidavit that she served first defendant Form 86 on 29 September 2021. The affidavit of service is dated 2nd November 2021. At page 22 of the case file, it is indicated that Form 86, dated 29 September 2021, was received by one Mrs. A.F. Ataikiru, confidential secretary, on 27th October 2021 for second defendant, the Governing Council of College of Education, Warri Delta State. The affidavit of service deposed to by Onwukwili Chisom on 2nd November 2021, however, indicates that she served Form 86 on second defendant on 29 September 2021. At page 24 of the case file, it is indicated that one Enderlin B, a clerk, received originating copy of Form 86 dated 29 September 2021 for third defendant in this suit. At page 25 of the case file, however, Onwukwili Chisom, a bailiff, deposed to an affidavit that she served Form 86 on third defendant on 29 September 2021. On the affidavit of service of Form 86 on first and third defendants, there is no indication therein that the judgment order was included in the process served on the defendants. As heard earlier in Udoji and another versus Ukaolu and other Supra, the law as stated in Epundu versus Diodeme and others per Uredola JCA is settled that before an alleged contemnor can be punished, the court must be satisfied that the party or person sought to be indicted for contempt has proper notice of the terms of the judgment or orders, and that breach of the mandatory or declaratory or injunctive order has been proved beyond reasonable doubt. The dependent, what is this? The defendant stated variously that they were not personally served with any Form 86 or 87 respectively, or Form 48 and 49. In reaction, the applicant maintained in her further and better affidavit in support of her application that the first defendant respondent and co-defendants were properly served Forms 86 and 87. In her written reply on points of law, the applicant argued that the bailiff informed her, and she verily believed the bailiff, that the secretary took the process to show the registrar, who directed the secretary to receive the process and sign receiving the process. This service may be in line with Order 7, Rule 1 of the court rules, but it does not certainly meet the requirements of personal service strictly demanded in contempt proceedings. That is my finding.
Court, please.
In Attorney General of Edo State and another versus Churchgate Industries Limited, the Court of Appeal heard per Bada JCA that what must be served is the order endorsed with Form 48. There must be proof of personal service, close of quote. I am not satisfied that the issuance and mode of service of Forms 86 and 87 on the defendants have met strict requirements of the law on committal proceedings. Where there is the slightest deviation or non-compliance with rules, a court of law must exercise its discretion in favor of the contemnor, and I so hold.
As the court,
The
please.
applicant, in my humble view, has not shown that the legal conditions for the committal of the first defendant respondent or the other co-defendants to prison have been established in this case, and I so hold.
As the court, please.
This application, in my view, lacks merit, and same is accordingly dismissed. Ruling is entered accordingly, and I make no order as to cause.
Very grateful. My Lord, sir, we're very grateful for the way considered the rulings. We are grateful, sir.
Much obliged, my lord.
You do the correction. Ruling in number 3, NICN OCA /43/2021 RO Okoye and others versus Mr. Christopher Obiekwe Anene and 4 others. Appearances in this matter? Could it not inform? Appearances in number 3, NICN OCA 43/2021 Okoye versus Anene and 4 others. They know there? Find out whether they're there. Find out from the State Council.